All right. The United States Constitution protects the right to homosexual marriage. That's my claim. I'm not debating the moral efficacies of it. I'm not saying, anything about the Bible or whatever. I'm just saying our right as a U.S. citizen is to marry whoever we want, whether that be a man, a woman. Well, that's pretty much your two choices. We haven't gotten that far. We're not that progressive. But as a heterosexual male, I don't ever plan on using this right. But as an American, I don't want my rights infringed upon, and I don't think you guys do either. Marriage it's a private matter, Who I marry is none of your business, none of your business. Who you guys marry is none of my business, It's a private matter, and I'm going to tell you, about the right to privacy. It's kind of it's implicit. A lot of you guys would assume that we do have a right to privacy to a certain extent. When you're in your house, you can do whatever you want. You have those different rights inside your house, and it's a private issue. And then also going to debate or tell you about the different Supreme Court cases that the Supreme Court has ruled against discrimination against homosexual couples. So the first case is Griswold versus Connecticut, which doesn't really have anything to do with homosexual couples, but it was the first case where Justice William O. Douglas assembled the right to privacy. Griswold versus Connecticut was Connecticut came out with a law that said you can't use contraceptives as a couple, a married couple. It's, they outlawed contraceptives, and then Griswold she was a worker for Planned Parenthood and challenged the case, said, the right to procreate is the right to not procreate. So in that case, Justice William O. Douglas, they assembled the right to privacy with the First Amendment, Third Amendment, the Fourth Amendment, the Fifth, the Ninth, and the 14th Amendment. So just by a show of hands, how many of you guys know the 5 rights that are protected in our First Amendment? Only a few of you guys? Well, the First Amendment is our right to free speech, freedom of religion, freedom of press, freedom to petition, and freedom to assemble. So in those rights, we all agree that those are, some of the rights we have. But he said in the case of Griswold versus Connecticut, in that there's an implicit right to association. The government, we have freedom of speech, but then they can't really tell us who we can talk to. We have freedom of religion, they can't tell us who we can pray to. So it's kind of implied that we have a freedom of association, we can associate with whoever we want, be friends with whoever we want, talk to whoever we want. The only people that can tell you that you can't is really your parents, but no one's going to listen to them anyway. You're going to hang out with whoever you want. So the First Amendment, really after those 5 rights, there's an implicit right to association. Also, he brought up the Fifth and the 14th Amendment, which is the due process of law, which means you can't be denied life, liberty, or property without due process of law. You can be denied it if you commit crimes or whatever, but there has to be a reason for it, which the two cases, U.S. versus Windsor and Hollingsworth versus Perry, they both say that they violate those amendments as well, so those are kind of important amendments. Next point is the U.S. Supreme Court has ruled that excluding homosexual couples from the same rights as heterosexual couples is unconstitutional. In the case U.S. versus Windsor, Edith Windsor and Thea Spire got married in Canada in 2007, and their marriage was recognized by the state of New York as a full marriage. And when Spire died in 2009, she left everything to Edith Windsor. So, her whole estate and blah, blah, blah. When she got it, or all her money and all the stuff that was left to her, Windsor had to pay $363,000 in estate taxes. She tried to claim the state tax exemption for surviving spouses, and heterosexual couples have that right as surviving spouse. You don't have to pay the taxes on all this stuff that's left to you. But she was denied that tax exemption, and the U.S. Supreme Court ruled that it violates the 4th and 15th Amendment under the Equal Protection Under the Law Clause, which the 14th Amendment says that that all U.S. citizens have equal protection under the law. It was created after the Civil War to protect people that have just become citizens after slavery was outlawed. but it applies to everyone. And this it overturned the DOMA Act, which is the Defensive Marriage Act, which defined it wanted to redefine marriage and spouse to only heterosexual couples, and the U.S. Supreme Court ruled this is unconstitutional, and said that you have to there's equal rights for everyone, whether they be homosexual or heterosexual. The next one is the case Hollingsworth versus Perry. Supreme Court ruled to that opposite sex. Hold on. Banning homosexual marriage is unconstitutional. I think most of you guys remember Proposition 8, which was created after the California Supreme Court ruled that it's illegal to ban gay marriage. Voters wanted to create Proposition 8, which redefined the California Constitution as a marriage between a man and a woman. So this went to the Supreme Court or California level. They said it was okay because they redefined the Constitution, and then when it went to the district court level, they overturned it, and then the Supreme Court ruled with the district court that it violates the 14th Amendment. It's freedom. The equal protection under the law. Sorry. We all have equal protection, whether we be homosexual, heterosexual, black, white, brown, green, red, doesn't matter. We're all Americans, and as Americans, it's our right. Whether we enact the right or not, we have the right to homosexual marriage, and I don't plan on enacting the right, but I just want it. It's an American. Nobody wants their rights infringed upon, doesn't really matter who you are. So, like I said, it's a private matter. We have freedom of association that's implied in the First Amendment, and the Supreme Court has ruled multiple times that it's not okay to discriminate against homosexual couples. Thank you. Blow back wall.
I was like, stop yelling at me.
I wasn't I'm not good.
All right, Bob, I think you've got a very clear statement of what your proposition is, and you defined that clearly at the beginning of the speech. I think that's good. The contents need to be organized a little bit more. You are relying primarily on the cases as the reference points, and that's example evidence, but it's not necessarily a good way to structure the claims of the speech. It seems that your argument comes down to 2 points. One is that the right of privacy, as these cases demonstrates, applies to the issue of marriage, and the other is that the Equal Protection Clause protects the rights of couples who are same-sex to marry also, and that there are court cases on that. So I think that those would probably be the 2 secondary points that you need to have more distinct. As it is, those are there, but they kind of get buried in all of the cases that you're presenting. Instead of the cases supporting those claims, it's like those are things that are a part of the claims or a part of the cases themselves. And I think that you need to, you're building an argument here, so you want to know what the secondary points are, how they advance that particular point. It'll be a lot clearer if you go that direction. On the cases that you cite, you are giving us paraphrases of the cases, summarizing what you believe the cases mean, and I'm not saying that you are inaccurate there. However, I think that there are several of the cases that you made reference to that don't reach the conclusions that you're describing, that people say they reach those conclusions. That's true, and I think that you need to be citing the legal scholars that say that that's what it means. For instance, the recent ruling, the U.S. versus Windsor. I'm not exactly sure that your interpretation of what the case law is, and the other one on Perry, that makes it against the law for states to have laws that prohibit same-sex marriage, because plenty of states continue to have that. If that's the Supreme Court ruling, then those states are all in violation of that, and there'll be further lawsuits immediately based on it. And I'm sure that there will be. However, I don't think that that's the way the law turned out with the court interpretation. There's a lot of nuance in court in the way the court ruled on those two issues. And I think that you're making a broader generalization on some of the cases than legal scholars would make on those cases. You would be better backed up if you were quoting, the attorney generals of the states who say, well, I guess that means this. Or if you've got a legal scholar from Harvard University Law School who says the effect of this ruling is, and we had a more authoritative interpretation of the case than just the kind of casual citation that you're giving us of the cases. So I think that that's where maybe the evidence is a little problematic. I like the idea of the use of the cases. The problem is that you're just citing the names of the cases, and then you kind of summarize what's going on there, and it's a paraphrase. And that means that it's your interpretation, but your interpretation needs some kind of support. And that's where there is dispute. That's why there's controversy on those issues. Otherwise, we don't have that. I think you do a nice job talking to the audience. There are a couple of points, just as an example, on the association issue. You say marriage is private, it's a right of association, so on and so forth. There are always, there are limitations on the issue of association. For instance, I can't refuse to have you in my class because you are a X, Y, Z, Q, R, S, whatever category you happen to fit in. So why don't I have a right to association? Because there are limits in public. Businesses can't refuse to serve somebody because of their ethnicity, their religion, any of those kinds of things. So there are limits on how association works, and this is one of the things that I was talking about, that there are nuances in the argument that I don't think you're quite getting to, that the scholarly research would help you make that argument a little bit stronger. All right, thank you.